It remains one of the most persistent misconceptions in the entire UK immigration landscape, an idea whispered from one hopeful voice to another, gradually solidifying into a widely believed myth. It's the belief that giving birth on British soil guarantees a straightforward path to citizenship, not just for the child, but also for the parent. The notion goes like this: deliver a baby in a UK hospital, and you're granted a golden key not only for your child's future, but for your own, a permanent right to stay, to settle, and to eventually claim British citizenship. But how much of that is fact, and how much is fiction? In this report, we're going to break that myth down completely and carefully, and in its place, we'll reconstruct the reality, one that's more nuanced, more legally complex, and far more important to understand if your future or your family's future involves the UK. So, if you've ever wondered what it truly means to have a child born in the UK and what rights, if any, that offers to the parents, this is a video you cannot afford to miss. We'll walk you through the process that determines a child's eligibility for a British passport and the lengthy, sometimes uncertain journey parents may face in seeking settlement. If you're joining us for the first time, don't forget to subscribe and click the bell icon so you never miss essential updates about life in the UK. Now let's begin at the very start. Imagine a child is born in the heart of London, or in the suburbs of Manchester, or perhaps in a hospital in Cardiff. Does that child automatically become a British citizen? For most immigrant families, the answer is a straightforward and unequivocal no. That's because the United Kingdom does not follow the principle of just solely the automatic right to citizenship based solely on birthplace. A child's citizenship in the UK isn't determined simply by where they are born. Contrary to popular belief, being born on British soil doesn't automatically make a baby British. The real deciding factor is the legal immigration status of the parents at the precise moment the child is delivered. To qualify for automatic British citizenship, at least one parent must either be a British citizen or hold indefinite leave to remain, commonly referred to as settled status. Without that, the child does not receive British nationality at birth. So, if you're in the UK on a skilled worker visa, a student visa, or even a spouse visa that hasn't yet led to settlement or worse, if you're currently undocumented, your newborn will not be considered British. Instead, the child inherits your current immigration status, or lack thereof. They may be born in Britain, but that does not make them British by law. Now let's consider a different scenario. Suppose your child is born in 2025 while you're still on a temporary visa. Then, 2 years later in 2027, you successfully obtain indefinite leave to remain. What happens then? At that point, because your child was born in the UK and you are now legally settled, you can apply to register your child as a British citizen. But it isn't automatic. You'll need to submit an application using Form MN1, pay the relevant fee, and go through the proper process. The law gives you this right, but only after you secure your own status. So that settles the child's situation. But here's the question that lies at the heart of the myth. Does giving birth in the UK give the parent any legal right to stay? The answer, in clear and absolute terms, is no. There is no immigration route that grants a parent legal residency just because they had a baby in the UK. You cannot walk into the Home Office, present your child's birth certificate, and expect to be issued a visa. The government has been unambiguous on this. Childbirth is not a loophole, nor is it a backdoor into permanent residency. A parent's immigration status is considered separately and must be earned independently, whether through employment, family sponsorship, or another legitimate visa category. If you do not have lawful status, the birth of a child in the UK does not create one for you. So why is this misconception so widespread? Why do so many believe that giving birth in the UK opens a path to settlement? The answer lies in a far more complex and indirect legal route, one that's centered not on the parents, but on the rights of the child. This is where things shift from an outright no to a more nuanced yes. But enter the 7-year rule. UK immigration policy recognizes that a child who grows up in the country begins to build deep personal connections to schools, to friends, and to the only home they've ever known. According to the law, a child who is born in the UK and has lived here continuously for the first 7 years of their life is eligible to apply for leave to remain based on their private life. When the Home Office assesses such an application, the key question is whether it would be reasonable to expect that child to leave the UK. And for a child who speaks English, attends a British school, and has never known life outside the UK, it is often deemed unreasonable to remove them. In such cases, the child is typically granted permission to stay. And here's the critical turning point: because a 7-year-old cannot live independently, their parent or primary caregiver becomes essential to their daily life. This opens a path for the parent to apply for leave to remain on the basis of being the primary carer of a child with lawful residence in the UK. This is where the parent re-enters the legal picture not through their own rights, but through the rights of the child. But let me be clear, this is not a fast track to permanent settlement. It is the beginning of a long, highly regulated, and often restrictive immigration journey. Parents granted leave to remain on this basis are typically placed on what's known as the ... And this is where the journey truly begins for the parent. That is, once granted leave to remain as the primary carer of a UK-born child, you enter what's known as the 10-year route to settlement. It's not a fast track, nor is it designed to be easy. Instead, it's a long-term, carefully controlled process. Here's how it works. Your visa will be issued for 2.5 years at a time. Every 30 months, you'll be required to reapply, pay the full visa application fee, and cover the immigration health surcharge once again. This cycle repeats until you complete the full 10 years. That means a full decade of paperwork, renewal, deadlines, and financial commitments. And during this entire period, you will almost certainly be subject to the condition known as no recourse to public funds, which means you won't be eligible to access most government benefits or support schemes. This route was created not as a privilege, but as a concession rooted in human rights law. It's a tough road, and it's meant to be. Meanwhile, your child's path unfolds quite differently and more swiftly thanks to recent updates in immigration policy. A child granted leave under the 7-year private life rule now qualifies for indefinite leave to remain ILR after just 5 years. That's half the time it will take you to reach the same destination. So, by the time your child is eligible for settlement, you may still be only halfway through your own 10-year process. Your child will have secured their future while you continue navigating renewals and restrictions, but that's not all. There's another vital legal right many overlook, one that exists completely separately from the 7-year rule. Section 1(4) of the British Nationality Act 1981 provides a powerful provision. Any child born in the UK who lives continuously in the country for their first 10 years of life has the right to apply for British citizenship. This right stands regardless of their parents' immigration status at that time. So let's put this into perspective with a real-world example. A mother arrives in the UK and gives birth. She has no visa and the child is not a British citizen. They live in the UK quietly for 7 years. On the child's 7th birthday, an application is made under the 7-year rule and is granted. The child now has legal status. Following that, the mother applies as the child's primary carer and is placed on the 10-year route. 2.5 years later, the child is now 9.5 years old. The mother must apply for her visa renewal. The child, on the other hand, is progressing along a faster 5-year path and will be eligible for ILR at age 12. But when the child turns 10 before even reaching ILR, they can apply to register as a British citizen directly under the 10-year rule. By that point, the child's legal status will be fully secured. The mother, however, will still have several years left to go applying, renewing, and paying fees until she reaches her 10-year mark and becomes eligible for ILR herself. And this, right here, is the truth so many people don't hear. There is no golden ticket. Giving birth in the UK is not a shortcut to citizenship, not for the parent, and not instantly for the child either. What it is the beginning of a multi-stage process, one that recognizes the rights and welfare of children and gradually creates pathways for parents through their care. and responsibility. It's a journey shaped by legal protections and human rights, not by convenience or automatic entitlement. So, if you or someone you know finds themselves in this situation, understand the reality. The birth of a child in the UK is a deeply personal, human event, but it is not an immigration strategy. It may open a door, yes, but behind that door is a long corridor with several checkpoints to pass and legal hurdles to clear. Your focus must remain fixed on the key legal milestones: the 7-year mark when the child becomes eligible for leave to remain, the 10-year mark when the child can apply for British citizenship. Fees moments are the anchors around which your own legal journey will be built. And one final note: this video is for guidance and public awareness only. UK immigration law is complex and case-specific. For formal legal support, you must consult a qualified and regulated immigration advisor or solicitor. Thank you for watching. I know today's topic was detailed and dense, but clarity is crucial when it comes to life-changing decisions. If this video helped you understand the truth behind this widely misunderstood issue, please give it a thumbs up, share it with your community, and subscribe for more clear and accurate updates on UK immigration law. Until next time, stay informed, stay prepared.